in the monthly list or which one is not in the list. But can it be given in any date? It will take not more than 10 minutes to dispose of.
And Union of India is represented by the same council in all the
Two
cases.
councils are there, Mr. Ramchandra Agarwal and then Shamrat Singh. I shall intimate through a intimation letter that that matter will be taken up any day. I shall intimate it.
You keep it on Monday, tell them. Monday, all these matters in a group.
Much of that. I have indicated which one are in the list.
Your
or not.
Lordship, may I be permitted to mention one MAT has been filed which was to be listed on 7th of this month. It is regarding the stay order passed by the Honorable Single Bench against the recruitment process of food inspector, Your Lordship, food sub-inspector by Public Service Commission. This matter may be taken up any day before.
You are up against the interim order.
Yes, Your Lordship.
When is the next date fixed there? When is the next date fixed before the on?
It is listed for the last 1 year, Your Lordship. It is not
For the
been
last?
taken up. More than 1 year.
1 year.
Yes, Your Lordship. It has not been taken up by Honorable Justice Shogata Bhattacharya, despite several mentioning, and it is an assigned matter before him. The
We should
applicants,
interfere in an interim order after 1 year. Why we should?
Lordship, these applicants are interveners.
You are for the applicants.
Yes, yes. They have not submitted any report before the Honorable Court, despite
It
the.
is in their interest that the process is not proceeding further. Otherwise,
Lordship may
they will-
kindly go through the documents, Your Lordship.
after holidays you mentioned, not this side. Sorry.
Yeah, my lords, kindly to mention item number 18, my lord, that matter where Mr. Sakur Sen is leading me, my lord, 2 p.m. fixed matter. My lord, he is in some personal difficulty today.
When?
He is in some personal difficulty.
What time is it at
2 p.m. fixed matter at, my lord, the first matter at 2 p.m. But I am mentioning upon notice.
Yes, sir. Receive notice.
You are
But I'll
making
not-
it difficult for us.
I will not trouble your lordship before the vacations, my lord, any day after the vacation.
No,
my
but
lord,
the longer time you take, the more difficult it becomes
I
for us.
appreciate, my lord, he is in some personal difficulty.
Any other one? Only you two are appearing. There is no other party.
No,
A prayer is made for adjournment.
Rule 29, sub-rule Roman 10 and 11, giving power the registrar to adjudicate the substitution application itself.
What is the last order passed by the tribunal? 2911 or
Yes, 29th 11, my lord, it was opined by the tribunal. This was single bench was there. Next order, my lord, 17 November 2025.
no? This is the next order. Oh, 25.
Yes.
So after 24 only, after 1 year an order.
Since, my lord, 30th September, the tribunal, my lord, became, my lord, memberless. But, my lord, rule says, my lord,
Rule says to return documents.
no substitution to dispose of the
Substitution where there is no question of abatement. So there is no judicial power vested whatsoever in the registrar.
But, my lord,
Therefore, we cannot create a jurisdiction in the registrar, which is otherwise not conferred by the statute. How can we confer such a jurisdiction? We cannot. But what is the way out? That is what we are trying to see.
But, my lord, I'm relying on a judgment, my lord, 2000 volume 8 SCC. There, my lord, paragraph 16. And the question of giving justice, court has power. Paragraph 16.
Court has power to confer jurisdiction in an authority which otherwise is not vested by the statute.
For principle of justice,
For passing orders, that is a different thing. There are judgments which say that even though we do not have those constitutional powers which Supreme Court exercise, ultimately all orders are to be passed in furtherance of justice.
or my lord, let's kindly grant my lord, leave my lord to be approached before the learned single judge, honorable single judge of this court. All judgment is
That
there.
is one option we were discussing.
That can be because it is my lord, uncertain, my lord, when that bench will sit, my lord.
Who is for the other side?
Well, I have served one state.
We will record an order that you do not wish to proceed with the proceedings before the tribunal. The same are dismissed as not pressed with liberty to. Yes. The learned advocate for the writ petitioner applicant submits.
Petition disposed.
Both OA and writ petition both disposed. You can take this back. Use it in an appropriate case.
But two.
Honorable Court, since the tribunal is not functioning and my original application is pending since 2015, it was hard price
Since
2015. It was,
all of a sudden it has become urgent
but it was
after 11 years.
It was hard price even in the 2020.
Then what is to be done?
It was hard in part. Twice it was hard in part. But
That is not, we are not going to entertain such matters.
Secondly, the Unitarian prayer is today people are, we are all at verge of retirement. We only
So what? You can wait for more than a decade, then you can wait. There is no urgency.
A very short issue involved in this matter.
We are not going to usurp the jurisdiction after a part-heard matter before the tribunal. We are not going to do that.
People have to kindly see just only two orders.
No, sir. We are telling you, get over the issue of, then we will go into these issues.
The orders, the matter has been hard.
First, tell us that it can be done.
That has been hard in part with the honorable.
Then how it can be taken up by an appellate forum or a higher court?
Tribunal. That bench is also not available.
You are now repeating the same submissions. You are trying to avoid or dodge the court's query. That will not help you. How can we do this? Pending a matter and partly heard, we will take it up. It's not something that it is just now you have filed it. There is an urgency. Something is going to happen in a day or two. You have waited for more than a decade. You keep waiting.
What happened is the new bench when the new bench come before the tribunal, the matter has to had hard again.
We don't.
This is not the case that
we don't know. That is not
available.
That will not justify us taking up the matter at this stage. That will not justify.
My lord, the issue is very short issue, my lord.
There are so many short issues. We will not take up every matter because it is a short issue. It can only be taken up in terms of the decision passed by the apex court. Roger Matthew is where there is no remedy available. You have waited for more than a decade. What is going to happen in maybe a month or 2 months, whatever it takes?
Tribunal is vacant for the last 1 year.
No, sir, it is not. It is vacant since September. We know very well. It's not vacant for the last 1 year. Factually incorrect submission, which we don't appreciate at all.
We are almost in June. But kindly consider, that's why it's
Nothing. Sorry. What do you want?
Kindly, my lord, kindly hear the matter on merit.
Huh?
Kindly hear the matter on merit, my lord.
We will not. We are saying so. You want us to pass an order or what? That is why we are waiting. We can say.
Give me a date's time, because I have to take instruction.
Take instruction. This is not the purpose.
March off.
Okay, it will come on Wednesday. Wednesday is all right.
Yes. Wait. But April 7th may be kept with the record. Affidavit of service.
Yes, affidavit is kept on.
But 3, Lord, I appear for the Union of India. Lord, both of us have agreed that let the matter be taken up after vacation because it has a checkered history. You don't have
Then you tell us the date. Why should we take up the file? Second week after holiday or third week after holiday?
second week or third week after holiday. After vacation. Second week after.
As joint.
That will be better.
My lord, I am appearing on behalf of the respondent writ petitioner, my lord. State is the appellant, my lord, and on the last occasion, as per
Any interim order?
there is no interim order, but as per your lordship's direction, we have filed the application, my lord. It is a checkered history in the for appropriate order. It is what happened, my lord, in this matter. Learned single judge has directed to regularize the service of the writ petitioners in the permanent post. And also, my lord, thereafter, my lord, they did not comply with the order passed by the learned single judge. Thereafter, learned single judge issued contempt rule against the principal secretary of the transport department, why he should not be sent to jail for 3 months. Thereafter, they went before the Supreme Court against the contempt order. Their Supreme Court has dropped the contempt proceeding, but at the same time given liberty to the writ petitioner respondent to approach before the Honorable Division Bench regarding the grievance in respect of the regularization offered by the state government. Well, here our contention is there is no pay
Let us
scale.
see where is the Supreme Court order. First was the Supreme Court order.
Well, in my application, my lord, we have your lordship, kindly see your lordship's last order. On the last occasion, state advocate has given, and also we have annexed.
Come to the Supreme Court order, sir. You said the Supreme Court has directed you to approach the division bench.
My lord, kindly see my application, my lord, page 18,
Application can number.
can number 3.
Which page?
Well, page 18 onwards, my lord. Particularly page 19. Liberty is also be given to the respondent to seek relief, which according to them have been denied to them while complying with the order passed by the learned single judge. And your lordship on the last occasion granted us also leave to file application. How we are aggrieved by the order here they have offered well consolidated payment but no pay scale is there. So for the permanent employee is concerned, there must be a pay scale, my lord. Second thing, there is no leave provision is there. And my lord, so far, my lord, so retirement benefit is concerned, they have offered, my lord, ex gratia payment instead of any gratuity, leave salary or pensionary benefit is concerned. And there is no provision of provident fund also.
So how will you raise your grievance before the division bench?
Well, my grievance is, well, whenever
How? What is the procedure for raising a grievance?
I'm made an application for an appropriate order.
How it can be? How by way of an application in the appeal filed by another person, you can seek a substantial relief? This was the law. This order we have read. Apex court said everything is over. Whatever grievance you have, you go before the division bench. You raise it. So can you do it by way of an application?
Because, my lord, they have offered us. We are not agreed with
We are not on merits. We are asking you what is the procedure.
Well, there is no question of cross appeal because, my lord, we have not agreed with the order passed by the learned single judge. Learned single judge has categorically directed them to regularize our service against the permanent post. They have preferred the appeal. And your lordship also, on the last occasion, condoned the delay because I have raised the against the their condonation, because then your lordship's view is as because you are not agreed with the order passed by the learned single judge, then if we not allow their condonation, then you are no here.
Anyway, let them be here. Nothing is to be done right. None for the state.
Seventeen.
But five is also same as 4, your lordship. Only the
The one
repetition
we
at
just
the
took up,
lordship.
along with.
Yes, both are appearing
Order.
together, your lordship. Orders were also
There
passed.
is no Supreme Court order.
But
They have
the
charged-
matters are appearing together before the honorable
Learned
division
single
bench.
judge, another learned single judge has passed the order in case of them, following the order passed in case of our
We'll consider when the state is there. List on 17. None appears for
Let
this.
the both the appeals appear together.
No, sir.
Because
You are
order,
totally different. Call the next case.
lordship, both the appeals were
Call the
appearing
next.
together.
Call the
Your
next.
lordship. Wait, your lordship.
No, 17th. Separate order, separate case. Not together.
But 6.
Lordship, item number 6 and 7, Lordship, both the matter, learned advocate on record for the appellant, Lordship, is not present today, Lordship, due to her illness, Lordship. I am only instructed that, Lordship, kindly keep both the matter, Lordship, after vacation, Lordship.
But only thing is, they said that whether we are an advocate or not, it will be clear. Your lordship, can see your lordship order. They will be the advocate or not. That is the fine. They said that.
Today again a prayer is made for adjournment.
Item number 8. While I'm for the appealing, on last occasion there was a direction to file the objection against the application for condonation of delay. My lord, he attempt was made to serve upon me, but I requested him to serve upon the advocate on record. My lord, that was not ultimately served, my lord.
Where is he? It will come on Friday.
My lord, instead of, if it is possible next week, my lord.
Why? What is the problem? Let him at least serve the copy.
No, my lord, if they will serve, then my lord, I have not seen what is written there. So I have to file, my lord, the reply to that, my lord.
That is why we are saying let it be served so that we can. Why you are filing objection? An objection is being filed. Item number 9.
Application for condonation of a delay of 77 days in filing the lordship. That is
Vehemently opposed.
Yes, sir.
What is the merit? Let us come.
lordship. The petitioner was punished in a disciplinary proceeding, reduction by 1 stage, lordship. Now the court has held that there is no illegality in the decision-making process. But the court has come to its finding regarding the quantum of punishment. That's all, lordship. Because he has, this is where he has reduced. Just placed here.
So even less than reduction of 1 stage.
No, lordship, it is for the not less than reduction of 1 stage. It's then the second part has been modified. Lordship, I'll just place it. And lordship will kindly come to page 38, paragraph 38 of the judgment. Accordingly, I am of the lordships have found it. memorandum of appeal. I'm of the view that the petitioner's punishment of reduction of pay by one stage in the times of scale of pay of rupees so and so in level 4 from rupees 35,300 to 34,000 for 2 years with the condition of no increments during this period should be upheld. However, the portion of the punishment that the reduction will have the effect of postponing his future increments on the part of the punishment related to the suspension period starting from 15/7/2020 to 28/1/2021, declaring that this period should be treated as not on duty and disqualifying him from pay and allowances should be set aside. It is ordered accordingly that the respondents are directed to impose punishment upon the petitioner in compliance of the order. The part of the punishment to the suspension starting from 15/7 to 28/1, declaring this period to be treated as not on duty and disqualifying him from pay and allowances to be set aside. That has been interfered.
Yes.
Lordship has seen, my lord, the honorable single bench, my lord, has, my lord, framed two issues. One was with respect to, my lord, whether the procedure for imposition of punishment was right, and second was disproportionate punishment. With respect to the first part, my lord, the honorable single judge, my lord, went against me. The procedure was right. But with respect to the second part, my lord, about the disproportionate punishment, my lord, could I just place your lordship, my lord, what has fallen from the honorable single?
35-36.
Yes, my lord,
Paragraph 35-36.
starting from 29.
No, what is it? Just tell us first.
Yes. So, my lord, the
What
honorable
has
court-
he found? What
Yeah.
is the basis for the court substituting its opinion for the punishment? And whether it is permissible in 226. This is the only.
Lordships. My lord, here the honorable court said that here the offense was, my lord, bringing an spy camera in the pocket, and the spy camera, pen spy camera, in a meeting. The motive was not present because my lord, the spy camera was not on, switched on. It was just kept. So my lord, it was held that the defense was taken by the employee that his wife mistakenly put the spy camera in the pocket, which my lord has been corroborated by the wife in the evidence. Be that as it may.
But that is not accepted.
Not accepted. Yes, my
So
lord.
therefore, that is not relevant today.
No, my lord, what happened?
Today, the issue is the Honorable Single Judge held that actually it stems from a personal dispute. It is not an, it cannot be held as a grave disciplinary,
Yes, my lord.
grave misconduct.
Yes.
And therefore, the DA has rightly opted not to give a dismissal. He has opted for a lesser punishment, but still, I think it should be like this. Now, can this be done?
No. That's subject to lordship's correction. That is perhaps not, my lord, the observation. I'll just place your lordship 2 paragraphs, but I was just saying, my lord, what has fallen from the honorable single bench, my lord, while my lord passing this particular order. It said that if the particular pen it was switched on mode, then the situations could have been different. But it was admittedly not switched on, only kept in the
Cannot be. If the punishment has not been, if the disciplinary authorities order conclusion has not been interfered with,
follow your lordship.
there is no scope for going into this.
Follow your lordship. My lord, if I just could place, my lord, 3 paragraphs, my lord, that is only relevant and nothing else.
Yes.
My lord, paragraph number 29, if I could place. The next issue that we will need to be addressed, my lord, it is in the internal page 15. Addressed is whether the punishment imposed upon the petitioner is disproportionate to the proven misconduct. The imposition of punishment in disciplinary proceeding falls within the domain of the employer, and such power is ordinarily not subject to judicial intervention. However, a limited scope for judicial review is permissible, and courts can intervene if the punishment is shockingly disproportionate, outrageous, or irrational, thereby suggesting a lack of good faith in the decision-making process. Now, my lord, it comes. The doctrine of proportionality comes into play when, after a careful analysis of the material presented before it, the court concludes that the punishment imposed by the disciplinary authority or the appellate authority is so extreme or unjust, it shocked the conscience of the court. Still, my lord, the court is not with me. My lord, para 30, rule 34 of the CISF rules 2001, which requires that such major penalties can be imposed for good and sufficient reasons. Prescribe 2 major penalties related to pay deduction. Well, these 2 parts, one is without future effect and another is not without future effect. This is mentioned. 31, my lord sees that. As mentioned earlier, in the present case, the disciplinary authority, by his order dated 29th of January 2021, imposed punishment to reduction of pay of 1 stage to such and such, 2 years to such and such, and that will not earn increment such and such, and the reduction will have effect of postponing of the future increment such and such. Well, paragraph number 32 is the basis for changing of this. Undoubtedly, no reasons have been provided to explain why the disciplinary authority imposed this particular punishment.
Where is the requirement of disclosing such reasons? Under which provision, under which law, that the quantum of punishment has to be sustained by a reason that for these reasons I am awarding this punishment in a departmental proceeding?
If I just could, my lord, continue with this. In this case, since the misconduct has been proved,
Yes.
the petitioner must face a punishment. If he is allowed to go unpunished, the same shall send a wrong message to the force. I cannot be oblivious that the petitioner is a member of a disciplined force where maintaining discipline is crucial. The petitioner must understand that the interest of the force will always take precedence over the personal. I'm sorry.
3 दिन से खोज रहे हैं जब बोलते हैं इतना बुक निकालते हो नहीं just see, check it. Yes.
It's fine. So after that, my lord, paragraph number 35, what I was saying, the misconduct appears to stem from a personal dispute between the, as your lordship has already fallen from your lordship, dispute between the petitioner and the family of another force member, and due to mistaken belief that his superiors were taking the side of Mr. Kumar and his family. There is no evidence to suggest that the petitioner had any intention Yes, ma'am. Sorry, ma'am. But there is no, this line, my lord, was the reason for which, my lord, this was interfered with. There is no evidence to suggest that the petitioner had any intention to capture confidential audio or video, or to use or transfer such data in a manner that would jeopardize the safety of the force or harm its interest. It is important.
We said at 35, 36, we said at the very beginning. We wanted to read from 29.
Or the basis I was saying.
This is the consideration which gave
Well,
in the mind of the Honorable Single Judge.
So, my respect,
36.
in my respectful submission, the Honorable High Court.
Yes.
Yes.
The offence is already proved. Then he has chosen not to interfere with the order. How he can do that?
The Honorable Court, even after my lord,
He could have set aside the order.
the Honorable Court says.
He could have mentioned.
The
There is a question of a punishment being awarded.
I say, my lord, the court, Honorable Court, my lord, has said that yes, there has been a misconduct. Yes. So, my lord, I also, my lord, did not challenge. So I am not saying something.
Therefore, that is final and conclusive.
But about the disproportionality.
Only the whether
This is only
in
the thing.
exercise of a judicial review under Article 226, it is open to the writ court to substitute its opinion in respect of the punishment awarded without recording how it is shockingly disproportionate. Where is that finding why it is shockingly disproportionate?
The punishment, my lord, has not been completely substituted. It says
It has completely been substituted. It's a different punishment altogether.
It remains.
The punishment which was awarded is not there. It's a different punishment. What more is a different? What more is interference?
I say before your lordship, my lord,
So therefore, the issue is that again, after so much of argument, we come down to whether this could have been done. What are you relying upon? Show me.
my lord,
Show us.
I will be, my lord, relying upon, my lord, the judgment of Ranjit Kumar
Yes.
versus Union of India.
Give the judgment.
My lord, I could provide your lordship with the, my lord, because I was
Come with
thinking
the judgments.
it is Ranjit Thakur versus Union
Come
of
with the judgments.
87 for SCC.
We have heard the learned advocate for the
19 of the judgment.
Why not? All the more better. You also give any
I've
judgment
already, my lord, given.
before.
Lordship is a delay control. Your lordship
Oh yes, the application.
But 10 and 11.
My lord, I am for the respondents, my lord. My lord, this is the matter where
Who is the writ petitioner?
state is the appellant, my lord. It's an appeal, my lord. Mr. Shirshanda Bandyopadhyay had completed his argument in this matter. My lord may recall this is a matter where the
After
data entry
holidays.
operators.
We can't hear it in absence of the writ.
Yes, my lord.
The state.
Great.
But well,
The respondent.
Lordship, this is the matter where your Lordship had given us to research a certain point whether the writ can appeal can lie or not in that point. My Lordship, I'm afraid we haven't done our research yet.
No, how much time? It cannot be endless. Cannot be endless.
Counsel, Mr. Shashankar.
12 and 14 are similar matters, well.
One is from the interlocutory order and one is from the final order. You can please let the matter come after vacation.
What happened after this date? What happened after this date? This is an order of 19/126. You are appearing.
For the respondent.
What happened after 19/126?
It has taken up appeal number 340 of 2026, or there are two appeals. One from the interlocutory order and
Yes,
from the
106.
yes. Thereafter, final order has been passed.
That is item number 14.
That is item number 14. Initially, my lord, they were reluctant.
We'll take up 14. That's what we are asking you. What
Yes.
remains in this case?
Nothing remains.
You are appearing 14 also.
Yes, 13, 14 both.
The present appeal arises out of an interim order. And 14 also.
Lordship, if my Lordship can please it after vacation.
Very
Okay, Mr. Shashankar.
as prayed by the
Kindly hear me, my lord. We were directed to go before the AIMS. We've been there. Thereafter, AIMS has also declared total blind in both the eyes, and that was the finding. My lord, 1990, we have not got any single farthing from the employer.
My Lordship,
proceed
the
and
disability
My lord,
law is
last
not disputed.
occasion, my lord, Mr. Banerjee submitted. They have paid us the entire amount, which is around 70 lakhs. My lord, my client is here. My lord, my client's son is here, and he says we have not received a single farthing. This is the bank statement. My lord, we have been suffering. It's almost 2-3 decades.
let's see. Give the file. 14. Give the file of 14. where we have recorded that payment has been made in which order?
My lord has not recorded. Only Mr. Banerjee submitted.
No, my lordship, as per my rememoration, my
Is this?
Then my lord, kindly do not fix it after vacation.
Why, sir?
My lord, otherwise, my lord, I have been suffering, my lord.
So who is stopping you? You take out contempt proceeding as prayed by the
For 13.
Affidavit of service.
you are served.
Yes.
How you can serve on this department? You have to serve on the respondents.
I have served on the Union of India office here.
That's what we are asking you, why you have served on the office, why not on the respondents? We have directed to serve notice on the respondents. How they will get the copies if you are serving here? And how they will send the instructions?
But usually we serve in the office for the Union of India because all the respondent authorities are from the Union of India. And that's why when we serve to the office, then they allocate the brief from there itself. That is what I was being instructed from the office itself.
It's not a question of brief allocation. It is a question of the respondent knowing that such and such case has been filed, in which such and such ground has been taken, so that they can send instructions.
I
Continue to
contacted the
this.
department, so they asked me to serve in this particular address. That's why I have done accordingly.
But this is not in compliance of the court's order. The court said to serve on the respondents. Court did not say to serve on the ministry department here. So there is no compliance. That day you could have said that we'll serve here and come back. But we have not said that. Let notice be served on the respondents. How it has been served on the respondents? There is no service. You have to serve on the respondents. Let the learned advocate comply with the
That I have filed along with this appeal. My lord, I have filed a CAN application as well. My lord, for reserving a seat for the candidate.
You are not complying with the court's direction and you want an interim order. We will not do that. Sorry.
Lord, I was
Sorry.
of
Call the next case.
Lord,
Give
kindly
you an
keep it
opportunity.
on next Wednesday. I shall serve all the respondents.
How can you?
My lord, because all the joining is being completed, my lord. My
You
lord,
are not, see, you have argued, we remember, we gave you a direction, you did not comply. Now what do you want?
because of this view that serving the Union of India.
Why you are required to take a view when the court has passed a specific order to serve on the respondents? Then why, who gives you the authority or liberty to take an independent view and act accordingly?
My lord,
How can you? You should have complied with the court's order or pointed out to us that there is an infirmity in the order, it requires some modification or clarification. You cannot take steps according to your own desire or your own understanding. It has to be in compliance with the court's order or not in compliance with the court's order. There's no third option.
the office of the Union of India, they only.
See, you are repeating the same thing. I don't know how it makes it any better.
My lord, may I please place this application, my lord?
You
Because
cannot.
joining.
Having failed to comply with the court's order, surely not.
Then kindly give me such indulgence that it be fixed on the next Wednesday. I shall serve in the meantime, my lord. At least before the vacation. My
Wednesday,
lord.
give the date of Wednesday.
I'm grateful, your lord.
In the meantime, since you have served it, we are not here to advise. Since you have served it, stick to the letter ASG.
For the applicant in contempt applications. Yes,
He is the writ petitioner.
yes, Lord. I'm the
And who are you?
he's my senior.
Go that side, sir. Go that side. Don't confuse us. You go that side. How much?
According to me, it is 231 days.
What is the error of record?
Order. Attention is drawn to the office of the author March 2000. His appointment is appointment. But the paper was not seen by the learned and also not here.
You want to re-argue the appeal? You cannot. Heard the learned advocate for the review. Nothing. Call the next. That you were required to do before the appellate court, not here. Yes. Call the next.
Item number 20.
Call the next. Not here. A prayer has also been at this juncture. The you're appearing.
Wait, please, Your Lordships.
You're for respondent.
I'm for the respondent.
Where is the appellant? None appears for the appellant.
Because right now, the matter of actually.
Yes. Order of the single judge is dated. There is any interim order? Is there any interim order operating against you?
No, my lord. In
Cons-
fact, my lord, I'll indicate that I'll show a chronology of the facts and I'll indicate, my lord, that this appeal should be dismissed. It's only a, my lord, ploy. I'll indicate that. Let my learned friend, my lord, make his submissions because the order is very clear. The point, my lord, which will fall for consideration is this. My lord, we had issued a notice, proceeding happened. My lord, in the meantime, in another proceeding, my lord, he was held guilty. He was convicted. So there's a provision, my lord, in the rules which provide for enhanced punishment, which includes dismissal. Because he was convicted, my lord, we'd given him another chance, show cause notice. In that proceeding, my lord, we had dismissed him from services. That's the issue. They take up a point of double jeopardy. My lord, the honorable single judge has explained this.
You have dismissed him twice.
No, we have not. The first time, my lord, was a lesser increment. That was for a different, my lord, because I'll show, my lord, the allegations against him are very, very grave.
So because it is a repeat,
it's separate, my lord. Indeed, it is a repeat, and in that, my lord, proceeding under the Prevention of Corruption Act, he was held guilty.
criminal proceeding.
Criminal proceeding, and that is why, my lord, the enhancement, and through the enhancement,
So
my lord, the dismissal.
conviction ipso facto can be a basis for dismissal.
Indeed, my lord, I'm very grateful, and that is exactly what has happened. That's the case, my lord, before your lordship.
And that conviction still sustains.
My lord,
That conviction sustains or it has been set aside.
sustains, my lord. And that's why, my lord, the honorable single judge considers this, sets out the facts, and my lord, we had relied on LIC's judgment, that on the point, my lord, very similar fact situation. And my lord,
In most of the service rules, a conviction is sufficient
Indeed.
to dismiss.
And I'll show the rules. That's
Under
very clear.
311 also.
Indeed.
Article
311 for the, my lord, government officials. My lord,
Yes.
indeed, my lord. So they really have no case, but if my learned friend wants to, my lord, submit, I'll.
Therefore, where is the order? Let's see.
Madam.
Where is the order? $291.
Before of that, timing not only on the portal, but also on the sign.
My lord, may I?
Just a minute,
291C is not the order. Where is the order under appeal? So it's in the memo, my lord, in the memo of
Wait.
291C is not the order under appeal.
But before my learned friend starts, may I have my lord's kind leave? I'll just come back. May I have my lordship's kind leave? Very deeply.
Yes. Gone through the order of the learned single. If Lordship might permit me, I shall start from the prima facie. Yes. Started from issuance of charge sheet. But it is a question of promissory statement. They have issued one charge sheet. Inquiry was proceeded. I was given the punishment, major punishment as per the CDA rules. And also, I suffered, but I preferred appeal. 1 year reduction of one rank for 1 year. I preferred appeal. That appeal was dismissed after suffering of my punishment. I have not come to the court. Now that means the charge sheet order, charge sheet specifically is under the estimate. Because if there is any provision, if there be any provision to be considered after that court, after that provision, then they have to issue second so-called notice, issue the charge sheet. That as to why they shall not enhance the punishment. Now rule says, I am coming each and all, but rule says, if a person under custody, trial in the lower court, then they can enhance the punishment. But that rule has become the sub-silent door that if there is any appeal to be preferred and sentence has been suspended, then what happened? The rule has not said so. Now, my lord, they have issued the second so-called notice. Who has issued the second so-called notice? Against whom I preferred my appeal. He is the appellate authority. When the appellate authority become the disciplinary authority. Kindly come to second so-called notice, my lord.
16/3/2020.
Yes.
Which page?
My lord, kindly come. Last page.
Last page?
No, my lord, I am coming. Second so cause notice, my lord, issued by 16/3/2020.
Which page?
My lord, that is 27.
Of which volume?
Volume 1. Subject to my lord, time condition and kindly come to page 29. First two lines. And also the seal and signature.
Where's your reply to the show cause?
Yes. Having my lord, kindly give some time. Because there are two volumes. My lord, kindly come to my lord, page 42. Volume
Page?
42. I'm sorry, my lord. That is 34. 34.
Is from 34.
Yes, my lord, volume 1. Subject to my lord, kind permission, I say there is no inquiry at all. Even there is no measurement full stop. And that is given by the auditor of Coal India Limited. Lord, I have repeatedly stated in my reply 34 to 41 that there was no at all measurement of food stock. Subject to my Lord kind permission.
Yes, we have seen the reply. We have seen the reply.
You have-
Where is the rule?
My lord, in
There
the
are-
rule,
Where
there
is
a-
it? Where is it?
already I have annexed.
That's why we are asking you, where is it?
Before coming to the rules, when they have issued the show cause notice, writ petition has been filed. My lord, just writ petition has been filed challenging the show cause. My lord Justice Amrita Sinha directed them to file the affidavit reply. They have not done it. Rather, they have issued the dismissal order availing the second show cause,
Very well.
cause of action.
Yes.
So this petition has been filed. My lord Justice my lord Partha Sen, learned single judge, he has dealt with the two matters, but he has dealt the order of the dismissal, but he has not dealt with the show cause notice, regarding the petition of show cause notice. Kindly come to my lord before definitely my lord says I bow down to my lord, but before of that, kindly come to order of Amrita Sinha.
No, no. So if we have understood what you are saying, according to you, the court has not looked into the allegation regarding the show cause.
Yes.
So where is the rule under which the show cause was it? That's why we are asking you.
Yes, my lord. Kindly come to my lord. Rule is there, but even I am placing the copy. Kindly come to my lord, page 15 first.
Page
29.
Page 229.
229.
No, page.
It's not
Paper book.
Oh, he's saying he has annexed.
I have annexed.
Where is it? Why are you not giving the page number?
I'll give him back.
181.
180.
Volume 1. That's the code, but they have. That's the code. The disciplinary rules they have not.
That is
The code, my lord, which is at
181.
no.
290.
292.
292.
292.
Starts from 292, volume 2. Then there's a backdrop, and the provisions are from 296 onwards, volume 2.
Kindly come to my lord, first chapter 1.
And the major penalties, clause 29 is 315 minutes. Page 315. Clause 29.
296, chapter 1. Clause 3.0, 2.1. Definition. Appellate authority means the authority specified in the schedule attached to the rules. Under the Coal India is my appellate authority. Subject to my lord, time permission. Had it been the case that my charge sheet, the charge sheet issued upon me, which is already become subservient to when I have suffered the punishment, whether my lord it can be reopened, forgetting about the promissory instrument or rule of law. If that be so, then it has been issued in the show cause notice. It has been explained in the show cause notice. My lord, most interesting is this, that in the rule says, if I am convicted in the trial, that immediately they can take the stress. But when I have paper appeal, sentence or punishment amount imposed has been suspended, appeal pending, that is remains subsilent on the rule. How they can issue the second show cause notice on the basis of the charge sheet that remains already been promissory stable. And also not that, my lord, the notice issued by the appellate authority, not the disciplinary authority. Had in the case that my disciplinary authority issued the notice and then impose the punishment, capital punishment. But a capital punishment says in the rule that is all major punishment. One major punishment has issued upon me, and also, my lord, I have suffered. I complied with that. How they can open the same charge sheet without having an explanation in the show cause notice? Second point is, my lord, when another coordinate bench single judge passed order for preferring the affidavit in opposition, but they have not considered of that. Not only that, they have not complied with the dignity and justice of the honorable court. Rather, they have imposed dismissal order on the basis of the same charge sheet. My question is a pure question of law, my lord.
Yes.
The pure question of my lord. If my lord kindly see page 114, my lord justice order of my lord Amrita Sinha. She has given direction, file affidavit in opposition, but they have not complied with that. Why they have not complied with that? My lord, it is their ego or any condition they are not complying the court's order, but they have issued the dismissal order. By whom? Who is an appellate authority. Once the appellate authority has disposed or dismissed my appeal after 1 year, that means already I have complied with the order. I have not come to the court having the benefit of justice and integrity, sincerity to the company. I have not come to that. Now, question is this: appeal has been preferred, appeal has been considered, appeal pending, and that considering of the appeal, there is no single word in the rule. In their open rule, how they can issue the dismissal order?
Yes.
Hello, there is some question, there is so many judgments, but I have not preferred because that is pure question of law.
Yes.
My lord is omnipotent, my lord. I am entitled, my lord, to have the benefit as well as I have 2 years, nearly 2 years service. I am not going to, my lord, double jeopardy, but I must refer section 26 of the General Process Act. Double jeopardy, my lord, on the basis of the single charge sheet, I should not be hanged twice. And those two punishments are major punishment.
The schedule is not annexed. The schedule of the conduct rules.
No, that is no. Entirely subsilento. If I prefer the appeal. If I have not preferred the appeal.
Schedule is not there even in this. Where is the schedule?
I'm bow down, my lord.
This, the one that I've handed over, is, my lord, a new rules. The old rules, my lord, the schedule is there.
Which page?
Kindly come to one of the next day, the next rule.
My lord, kindly
Because the
see,
rule is totally based on.
it's from page, my lord, 325 onwards. volume 2. The forms are given, my lord. All the forms are there, madam.
No, this.
This is, my lord,
That is
the schedules are also, my lord, all there.
That is stated in.
This is the annexure. It's all there.
Where is it?
CMD is no longer, my learned friend cannot say that CMD is not my capital.
Where is it?
Here it starts. All the annexures, my lord, are from 345. That's annexure 2. It's still 346, my lord. These are the annexures there, or the forms and annexures.
See, you must. Shoot.
The schedule is, my lord, 349. I'm sorry, 343. It's been written as if it's 9. It's 343, my lord. Schedule under Rule 27 is given, my lord. 343, volume 2.
And he is working as. He is of which rank? Grade of employee?
My lord, kind permission, a schedule is there. Who is the appellate authority? Who the board of directors?
He's a
My question is this, my
man-
lord.
He
Who
is
is that? They can issue.
the mine manager, my lord.
So in which grade?
So he will be, my lord.
My disciplinary authority, appointing authority is the CMD of the Coal India subsidiary, ECL.
Directors with delegation can do it, my lord. This is officers in the grade of E1 to E5, everything. I have to take instruction, perhaps 3B, my lord. 344.
Not required.
It's not required, really, my lord. I'll indicate from the facts, and now once my learned friend is done, I'll quickly take your lordship to the
No,
chronology.
he has submitted
My lord.
that there is a charge memo. Based on that charge memo, he suffered a punishment.
Lordship.
He preferred an appeal. His appeal was rejected. He has accepted it.
My lord.
Now he has accepted it. Therefore, there is a estoppel operating against you to take further action on the basis of the same charge sheet.
Very good. That's not
Because there is no further charge sheet.
Right.
By issuing a show cause, the punishment has been imposed. That is a submission.
That's a submission, my lord. Now, my lord, I'll quickly indicate. I'll premise, my lord, my submission on this. The second show cause notice, which is for major penalty, is based on his conviction. That something is not shown.
That is not stated here in second.
You have already, please, this is not the
And
way.
that I'll take your lordship through.
Yes.
And what is the allegation against, my lord, this employee? Your lordship will kindly take up the memo of charges first,
No,
and I'll start from
before
there.
that, we are rather grappling over this, whether a show cause was required under 34.
34, my lord, this is the second show cause notice, if that's what is following from your lordship. My lord. Second show cause notice, I'll
Does
quickly-
34 contemplate a show cause to be given before the order is
Not
passed?
really, my lord. I'll show that show cause notice for enhanced penalty, and that's because the court has held. Lord, may I only indicate very briefly few pages. I'll start with, my lord, volume 1. Kindly take up, my lord, page 170. That's the first memorandum. In the year 2012,
That is finished.
the 26th of July 2012. The typed copy is
So
at
there
page
is a
171.
proviso to 34.
My lord?
There is a proviso to 34.
There is a proviso to 34. I'll take your lordship. 34, 37, 29, and 31. These are the provisions I'll rely on. But before that, not quickly, I'll indicate, we'll run through the chronology of events. Where there's an articles of charge in the memorandum of charges. That's at page 176. Two broad charges, my lord. Kindly see page 176, article 1.
That is not relevant today.
Not relevant, my lord, but I'll only indicate what defalcation of amounts
That
they
is
have done.
Not relevant today.
Very well, my lord. Then there's an order in
See,
2015.
34
Lordship.
can be made the basis of passing an order.
34 is the special procedure. That's all, my lord. That's all. I'm very grateful. In fact, 34.11. That's all, my lord. That is the basis on which this order is, and I'll show it. I'm very grateful. That's the crux of the matter, my lord.
No. Because
And my lord, may I only show the first
I
order?
have submitted
I'm
my
sure
lord,
my learned friend will not trouble me. I'm sure that. Sure.
You are senior to him. You want him to learn this from you.
I am
You want him to learn this from you, that he should interject after every submission of the other side.
My lord, I am
Please sit down. Please sit down. This is not the way. This is not an open forum that you can discuss an issue endlessly. Please sit down.
My lord, the order in terms of this, my lord, charges of 2012, worship order, please, was passed on 10th of September 2015. This, my lord, starts from page 200, volume 1. There was an appeal preferred by them.
That he has said. That
an appeal, my lord.
Yes.
Thereafter, in 2015, in the meantime, my lord, there was this procedure led to another show cause notice, my lord. And this is the first procedure, and that your lordship will find at page 252. Then there is a Bombay High Court decision where, my lord, this matter is remanded back to the authorities. They had raised an issue. I'll only indicate the relevant part. That's page 227, the last paragraph of Bombay High Court, where, my lord, because there was a second notice and they had challenged that notice, the Bombay High Court, my lord, indicates that let this be relegated back to the disciplinary authority. That's paragraph 13 at page 227.
This was writ filed by
my learned friends, my lord.
in Bombay.
In Bombay, this is, my lord, because there were other officers. There's separate office, page 224 it starts, my lord.
No, where is the first page of
the cost title is not here, my lord. My learned friend has not annexed, but there's a, my lord, it says late Radha Kantiji Sharma versus Coal India. So, my lord, similar proceedings, it was remanded back. This is their petition.
We don't know whether it applies.
Indeed, my lord. Now, thereafter, my lord, there is a circular at page 231, an RTI that they had preferred. I'm not troubling your lordships with that. Then a criminal proceeding, because they had filed, my lord, for quashing at 241, that was rejected. MP High Court. Rejected, my lord. Now comes the present proceeding. What my learned friend was showing, I'll rely on that itself. Page 245, volume 1. The first writ that they had preferred, they had prayed for some interim reliefs. That was rejected by the Honorable Court. The Honorable Court said, I will not enter into this.
241.
245.
That is the order of subject to my time permission, may I say?
No, I'll indicate that my learned friend may thereafter.
245 is an order passed in the earlier
in a writ petition before this Honorable Court. In the first proceeding, madam.
46, my lord.
So he had challenged the charge memo in that.
They had challenged the charge memo. My lord, kindly see the third paragraph. Whether the said rule can be made applicable in the instant case has to be decided at the final hearing. Then, my lord, this will be, lord, subject to outcome in this writ petition. That's what, my lord, has been held. Thereafter, this is important, my lord. Kindly see, my learned friend will kindly bear with me for some time. 245, my lord, page 245, the second paragraph is relevant. A show cause notice of 4th December 2018 is referred to. So it's a subsequent show cause notice, my lord, not the 2012 show cause notice. Page 245, the second paragraph. Because they apprehended dismissal at that time. That's why they filed this writ petition saying stay the dismissal. We are apprehending a dismissal. With this, my lord, kindly take up. The order that was passed. Now, this is very important. Page 251. 252 is a typed copy. The reasoning behind this present order. Page 252, my lord. And I should also indicate this is the outcome of page 27, volume 1. So if your lordship takes up on one side, my lord, 27, volume 1, that is the show cause notice, the subsequent show cause notice, dated 16th of March 2020. So why this second show cause notice, I'll indicate, my lord.
Page 27.
Page 27, volume 1. For the enhanced, my lord, penalty.
Yes, we have already seen that.
That's, my lord, that's the reason why. So this is, your lordship will kindly take up. This is perhaps.
That is not the second show cause.
I'll indicate, my lord. Kindly take up page 28, the next page, my lord. The first two paragraphs are relevant. I'll only indicate that. In the first three paragraphs at page 28, my lord, before I read out the order.
Where is that? Sorry, where was the rule? Which page?
My lord, the rules. I'll indicate. It's at page 315, the relevant rule, my lord, 37. It's volume 2, my lord.
Starts at 292.
292 onwards. And 34 is at page 320, my lord. Page 320. And I'll trace reliance on 34.1. May I, my lord, read out the first three paragraphs at page 28. The enhanced show cause notice, my lord. the show cause notice for the enhanced punishment. My lord is looking at 34.1, lordship.
Just give us a minute.
Last time, judicial trial.
What is the date of the earlier punishment which was imposed on him?
So the date of the earlier order was 10th of September 2015.
That is the punishment.
That's the punishment, my lord. That's at page 200, volume 1. Volume 1, page 200. And my lord, the operative part where, my lord, there was an increment reduction to one stage lower is at page 201, the third paragraph. The first proceeding, my lord.
You are giving him a
Page
notice for
201.
enhancement of penalty.
Lordship.
You are giving him a notice for enhancement of penalty.
That's not really required because, my lord, notwithstanding, that's how, my lord, 34.1 starts. Notwithstanding anything contained in Rule 29 or 30 or 31 may impose any of the penalties specified under Rule 27, which is not the major penalties.
But this is notwithstanding other provisions, not section 37.
In the 37, I'll come to me. That's a review. That's a procedure for review.
You have given him a show cause under 37.
My lord, the subsequent show cause, your lordship will kindly take up.
That show cause is at page 27.
27. My lord.
Yes.
At page 28.
Yes.
Is the operative, my lord. Those first three paragraphs is what I'm referring to.
Sure.
My lord, there are two show causes, my lord. One in 2018, against which, my lord, they had preferred a, my lord, appeal.
There is an earlier show cause also.
Yes, my lord. 2018 and then 2020. I'll bring, my lord, if your lordship so pleases, a list of days that will make it easier.
Where is the 2018 show cause?
The 2018 is referred to, they have not annexed, it is referred to at page, my lord, 245 in the judgment, my lord, in the order passed by this honorable court, the honorable single bench.
That show cause was for what purpose?
My lord, directed the petitioner to show cause as to why enhanced penalty of dismissal from the service should not be given.
No, that is page 27.
My lord, that's the dates are different. My lord, 4th December 2018. Your lordship will take up page 245, volume 1, the second paragraph, my lord. That's the reason, my lord. Date is 4th December 2018. That's referred to. Volume 1, page 245, my lord.
My lord, that is the subject to, my lord, kind permission.
Page 245.
Page 245, the second paragraph, the honorable court records, vide show cause notice dated 4th December 2018. Chairman cum Managing Director of Coal India Limited directed the petitioner to show cause as to why an enhanced penalty of dismissal from service of the company commensurate with the grave misconduct committed by my learned friend should not be imposed on him. The petitioner was granted liberty to.
That's immaterial. You have acted upon the show cause of 16/3/2020.
And that is, my lord, the subsequent proceeding, which is not.
You have not acted upon that show cause. You have
We
acted
have not.
upon.
That is why, my lord, when my learned friend made that submission.
So the question still remains: 16/3/2020 is issued under 37 or under 34?
My lord, the show cause is, my lord, starts from page 27, and I'll quickly indicate, my lord.
Nothing is there.
34.1. That's, my lord, second line at page 29. That's my case, my lord. 34.1, your lordship will kindly take up page 29, the second line. Undersigned, Chairman cum Managing Director is issuing this show cause notice vide Rule 34.1.
Page?
My lord, page 29. Volume.
So it is under
That is, my lord, that's my case. 34.1 specific, not 37. That was the previous notice, my lord.
That was a previous notice.
Yes, my lord. And this is where, my lord, 34.1.
That was of which date? 2018.
My lord, this notice is, my lord, 16th of March 2020.
No, that notice, earlier notice was.
No, that's 4th of December 2018.
They have not conducted anything.
December 2018.
18. And this my lord, pursuant to which this order was passed, which is, my lord, challenged by them, is 16th March 2020, under 34.1, not 37, my lord.
So this show cause was not challenged.
No, my lord.
This final order was
This
challenged.
final order was challenged from this show cause.
A show cause of 18 was challenged,
My lord.
and the final order passed was challenged.
And final order is under the show cause of 16th March
So
2020.
that show cause of 2018, because your this authority
That they have not annexed, my lord. I've checked that.
The authority who has issued the show cause of 16/3/20,
My lord.
he has considered everything that went on prior to issuance of that show cause. So in his show cause, anywhere he has referred to the 2018 show cause.
No, my lord. They have not annexed really this show cause of 4th of December.
How many times you will say that? How many times you will say that?
Sorry.
We are asking you whether that 2018 show cause is referred in the show cause of 16/3/2020.
I'll quickly check.
Just check. That is what we are asking you. We just want to know whether he has dealt upon it or not.
I'll indicate. Have you checked? Please check before telling me. Please check. I don't want to make wrong submission. It doesn't appear. No, my lord. It is not.
So perhaps because there was an order passed by the Red Court, they did not proceed further in the 2019 show cause.
2018 show cause.
2018. 4/12/2018. And the final order disposing of the two writ petitions. Does it consider 4/12/2018?
I'll quickly check that. The final order is 18th of August 2020, and it starts from page 252. I'll quickly check. I'll give you a moment. It refers to the proceeding of 2015. I don't find a reference to 2018, my lord, but the last paragraph at page 253. Second last paragraph records that this is a conviction under section 409 IPC. Hence, 34.1 is applicable, and they proceed on the notice
Sir,
of 16th.
we are asking you.
But it's not. It is not.
The single judgment which is under appeal.
On that minute.
Whether in that case.
In the order. Kindly grant me a moment. I'll just check that quickly.
It is at which page?
It starts from. It's in the. I'm seeing it from the memo of appeal, Miller.
Oh.
From the memo of appeal.
Not from the paper book.
No, Miller. Paper book is that one.
Anyway, don't worry. You just have a look. We are finding.
Fine.
देखिए बोल सकते
291 my lord.
Yes, we have got it.
My lord. Volume 2, 291 D.
Order 393.
No, my lord. It's not referred to, my lord. The dismissal order is.
No,
yes,
no. Just wait, please. Come to 4291C.
91C.
Page 291C.
Lordship.
The cause title is WPA 6861 and 5769.
Very grateful.
What happened in 3932 of 2019? Page 245. Now please refer to 245. You will appreciate what we are asking you.
3932W. What happened? It's pending. There's no development in this proceeding. It is pending. 3932 is pending. I should not be making my lord wrong statement. There's no instruction. I have to check and come back. Perhaps it's pending, but I shouldn't be making.
What happened in 3932?
It happened. It's pending then.
Page 245. See page 245.
The order of 26th March 2019. That proceeding.
That is the order I refer. That is my lord. That is the order of my lord.
What happened in that case?
Thing, my lord.
It is pending.
It is not pending. My lord just a same single bench passed the order in considering two writ petitions. But the first writ petitions, if you kindly go through the order, my lord justice single bench has not referred, has not explained anything about the petition.
So according to you, this petition was decided along with the second writ?
Yes, but that is
no.
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 Kindly consider the order.
Kindly see. Before
Kindly
you make your submission,
consider the order.
Please first come to 291C. Come to 291C. Where does it say WP 3932? Come to 291C. To 91C, you have 291C.
Yes, my lord.
Now from volume 1, you open 245. Both put them side by side. Open 245.
My lord. I bow down.
What is the writ petition number?
3932.
Where is the order passed in 3932?
The matter is listed today at the instance of the
Read at the top. What are the case numbers?
6861 and thereafter, my lord, 5763.
Where is 3932 order? You are saying it has been passed but not considered. Where is 3932? 291C.
There is another order.
You don't know anything. You are just making loud submissions.
Kindly grant us a moment, but we are just crossing. We should have checked this because this is
It's not considered. Another petition has been considered. With 6861.
You don't know. You don't know anything. Otherwise, you would have told us. What happened in 3932? You are the petitioner in all the cases.
That is the petition filed by me and they have given the order.
What happened in 3932? We are asking you again.
Yes.
Where is the order passed in 3932? You have not shown us.
Mala, that is not passed by single bench, Mr. Sen.
Where is it today? Where is that writ petition today? It is pending. Just now you said the order has been passed by the single judge.
Yes,
You don't know. You are not aware.
Challenging Mala, the dismissal
You don't
order.
know anything. You are just making off the cuff submissions. Most unfortunately. You don't know.
Let's check.
This is not your consultation chamber. Go and find out.
But we have just checked from the website. The last order is this. There is no other order.
So where is that case number, sir?
Your 3932W of 2019 is
Yes.
pending adjudication. This is the last order. There is no order after
It is
this.
pending.
It's pending.
Just see. He doesn't know.
We just checked, Milord. It's
He's
pending.
saying that the order has been passed
It's from
by
the High Court
Justice
website
Tain,
that we are checking.
but
Milord.
without considering
I'm
any.
now saying this with responsibility.
You don't know, sir.
Different
Unfortunately.
proceeding altogether against
Mala,
that
I
2018
am
notice.
most unfortunate. I am most unfortunate. But question is this. Mala, kindly see the page 291C. That is mark with
Perhaps it has become infructuous now.
It has become infructuous.
Nothing can be done in that
Because
case.
2018, the proceeding is not proceeded
It's
with.
not proceeded further.
And they have not challenged the 2020 Milord proceeding.
Anyway, so then that is all.
That's all, Milord.
Any,
Milord, I have some
any reply you want to make, you make it.
regarding of
Reply to his submission.
Milord,
He's
I am
re-
carrying those line of
may I
judgments,
submit to
Milord.
proceed,
Where
he's relying on 34.1. That is all.
34.1
I'm not troubling your lordship with those judgments, Milord. The basic judgments that Milord
Give
is.
the LIC judgment. Show the LIC
Milord,
judgment.
the LIC judgment, Milord. LIC judgment, though. It's Milord 2020 12 SCC 144, paragraphs 12 to 19. Now, why not? No. Paragraphs 12 to 19. Paragraph 13, it is quoted below 39G. Sure. The copy has it. 12 to 19. 12 onwards. One minute. One title. The paper. The extra copy বের করতে পারো। বারো থেকে 19। 12 থেকে 19। আছে তো বলতে পারছি। W 2019. But how is the super notice date matching? আমরা এবার একে ব্যানার্জি versus what is this? No, this number is matching. Registration number, filing number. The registration number. এই তো order দিন। Madam, month. আমি বলছি আরে এটা অন টাইম এটা অমৃত আছে না বাট দিনের জন্য
That is all.
So this and may I refer to two decisions, my lord? Only on the point of my lord judicial review. This is my lord well known, but I'm just pleasing Praveen Kumar. My lord, copy. Give me a copy.
Speak in English. I also want to understand what you are telling him.
My lord, I used to practice in Patna High Court. I have also, my lord, come to learn about my lord before my lord elevation. My lord was a very stalwart.
No. I am a learner for life.
Even today also.
Yes, I am
Subject
a
to my lord
learner.
kind permission. I want to make a single submission, lord.
Just after he makes, you will make your submission.
Milord, I'm referring to paragraphs 25 to 30 on judicial review in a service matter, and I'm also, Milord, relying on a recent judgment, State of Rajasthan versus Bhupendra Singh.
That is sure how it arises. We are not reviewing any action taken.
Only this, Milord, only this. I'll not burden your lordship with further judgments. May I only place
This judgment, what is it for? On
the
which
judicial review, Milord, in a service matter is not to be, Milord. The scope is just discussed. That's all.
But there is no finding which we have to reappreciate. Whether this could have been done under 34(1) or not, that is the only issue. So
I'll not burden your lordship with the other judgment. That's all service jurisprudence.
he is not challenging the order of punishment because he has accepted that. He says you are stopped from doing it. That is his case.
That's his case, Milord. And
Yes.
my cases, we are
Because
not.
that
of the
charge
subsequent-
memo culminated into a punishment. He has accepted the punishment. It is over.
I am
Therefore,
not.
second show cause on the basis of the same charges cannot be. That is his case.
That's his case. That's for 37. My case is 34.1.
Yes.
It's a separate proceeding altogether, and this proceeding started after you were convicted in
Your
2008.
case is that the formal will not foreclose the latter.
I'm very grateful. Also, one submission, I'll fail in my duty if I don't do that, my lord. The second show cause notice was, my lord,
Specifically under 34(1).
under 30, second show cause notice of 2018.
Ah.
It was under 37. My lord. That's
That
review.
was for enhancement.
That's for enhancement. That's review. We are not on that. We are not on that because thereafter, my lord, he was dismissed. I mean, he was held convicted, my lord, and that's discussed in the order.
That is
And that is the
slightly-
reason
that
34
that is slightly difficult to accept because the date of your notice is of December 2018.
I understand that, my lord. This is October, but then December was
Forget
37.
it. That is neither here nor there.
Okay, but that's-
We are not concerned with
Not
that
sure.
writ petition.
That is only for a review under 37. This is a new proceeding under 34.1.
When that comes up, whatever order has to
I'm
be
very
passed,
grateful. I'm very grateful. Are you sure about this? Show me. But the same judge. No, the order is given. Anyways, take it. My learned, I'm getting instructions, my lord. I'll be candid. My instructions
forget
are
it. We are not concerned with that.
that
Yes.
perhaps this writ petition is wrongly, my lord, placed because this doesn't have a cause title, and 3932 from the records is some other matter. It's some different writ, and that is why, my lord, that is what the instructions are, that this is a different writ altogether, and this is not really a writ in the name of this petition, and it has been disposed of by an order of, my lord, 18th February 2021, where this WPA number is mentioned, but this is WP. The WPA number is the same, 3932 of 2009.
Submission.
That's
Have
the
there been any lapse? That is the part of the department. Because my lord was just a senior
Anyways, I'm
advisor.
sure my learned friend is addressing the honorable court and not me. But my lord, this is my respectful submissions. I'm only on 34.1, and I'll not burden
And
your
the
lordship.
interim judgment disposes of two writ petitions. That is clear.
It does, my lord. It does.
6861,
6861 and 5763.
It starts from 291D.
My lord.
This appeal arises out of the 10/5/23 or judgment.
My lord, this. Yes, my lord, 10/5/23.
But 10/5/23 is passed only in one case, WPA 6861. It is not passed in any other case.
All the cans connected there too. Yes, my lord. In fact, we are only concerned with this, my lord. We're not concerned with the other matter at all. My learned friend submits, it has become instruct.
Must be, he is correct.
He's
He is correct.
These are my respectful submissions.
Any reply you want to give?
Yes, ma'am. Only 34.1.
Yes.
34(1) says that if an employee convicted under trial, then the authority can take or enhance the punishment. There are two aspects. Ratio of descendants shall come in forth. Firstly, the rule 34(1) is remain sub silento when there is provision for appeal. Suppose, my lord, I am convicted in a murder case. I prefer an appeal. Appeal has been admitted. If I under bail during the trial, I should have been enlarged the bail. That means the orders of trial court cannot come in forth. That point should have been considered. There is the ratio, the when preferred in appeal, and for the ratio, no preferred in appeal.
All right.
If no preferred in appeal, 34.1 come in forth.
Very well.
Correct, my lord. Secondly, who shall issue me the dismissal order? My disciplinary authority. That means the chairman of Coal India Limited, ECL. ECL, CMD, ECL, subsidiary under Coal India Limited. They shall or he shall or she shall issue me the dismissal order. How the chairman Coal India Limited can take the hands and pass the dismissal order to me, avoiding the ratio between the disciplinary authority and appellate authority? My humble submission before my lord is this. My lord, is a pure question of law. No question, no judgment is required. What the judgment, two judgments has been submitted by my learned junior friend. My lord, this is not relevant. My lord, may I submit to lordship? My lord, only one thing can assist you, my lord. Section 26 of General Procedure Act. Because they are stated two enactments. If there are two enactments, my lord, if it is CRPC, right now BNS or BNS and service jurisprudence, if the rule of the company does not permit, my lord, has not amended in sense of 34.1, then how, my lord, they can pass the capital order to me? Capital order, my dismissal under enhancement. But before of that, they have issued the major punishment. I suffered. Same charge sheet. My lord, this is a pure case of promissory estoppel and rule of law. Pure case, my lord. Rule of law and promissory estoppel. I shall not repeat and reiterate, my lord, my earlier submission. I bow down to my lord. What my lord passed the order, I bow down to it. But I am entitled to get the justice.
Yes, take down. Heard the learned
it is a different writ petition altogether, my lord, of a different party. The cause
When
title is not
when
here,
the
which has
petition itself become the infractuous.
no, which has been disposed of. This is
Whatever
not
may be,
related to this matter at all.
Kindly,
We have
if
just taken
lordship-
out the printout from
just
the
a
court.
minute. If
But
lordship-
this is the disposal.
It is of a different writ.
Absolutely different, my lord. Although Coal India was a party, and this is the review which has also been disposed of, my lord. At the top, the date is 21. It should be 22. This is 21. So it's a different matter altogether. It's not this matter at all.
Same point of law,
But that is not how it's been pleaded, my lord. That's not how it's been pleaded.
lordship kindly also record only one single point. Only
Should
single
we
line.
should we consider this aspect?
No. My submission is this, my lord, 34.1. You kindly have to consider of this only single line that in case of appeal, the rule is subsidiary.
I'm very deeply obliged.
19. Item number 19. We are the appellate expert. Where the matter pertains to Milord, primarily
For the respondent number 4 PM. Respondents are present. All respondents are represented. I represent 4.
the petitioner is not here.
Today they are not present. You are for respondent number? Is 4.
KMDA, Kolkata
KMDA.
Municipal Metropolitan Development Authority.
And 1, 2, and 3.
We are the appellants. That is Kolkata Municipal Corporation.
Yes.
1, 2, and 3 Milord are the writ petitioners.
So they are not present. Have they appeared earlier?
Yes.
They have appeared.
It was I who was taking time every
Yes,
time.
last 2 occasions you took. But see, one of them is state of the state.
State is there, no?
3. So they are presently they are not appearing in any of the matters.
Oh, yes.
Respondent number 3 is a state, and 1 and 2 are perhaps private. Probably the writ petitioners before the writ court.
Yes, 1 and 2 are the writ petitioners.
They have appeared actually. My Lord, I stand corrected, my Lord, not 4, 7. We thought so. How? I was myself one. How can we proceed?
But Milord, I find Milord, of course, Milord, subject to your lordship's consideration, that state did not appear before the learned single judge also.
No, respondents 1 and 2 were represented. Mr. Jaideep Kar was representing them earlier. Is there any interim order also obtaining?
That's what is. That's what is.
It is come by assignment.
It's an intra-court appeal. Your lordships have the determination, I believe. Yes. But under the municipal laws.
What is the issue?
But the issue over here is primarily twofold. One is Milord regarding mutation. The other is, which is very important, is annual valuation. Now the point is whether the annual valuation would be under section 174 of the KMC Act, which is our contention, that is the KMC's, or Milord it should be under 176, which is the contention of the writ petitioners. Where the writ petitioners' contention has been upheld. Against that, Milord, we are before your lordships, Milord.
Both these provisions deal with the valuation of property.
Yes. Milord, a judgment, Milord, has been relied by the learned single judge, which in our respect submission would not apply because there has been a subsequent amendment. Subsequent to the judgment, that is commonly called, Milord, the Fabworth judgment. So this is the issue, Milord. I won't be.
How to proceed in absence of the writ petitioners?
Very well, then your lordship may keep it sometimes next week.
Please intimate them. Yes.
Ms. Sengupta was suggesting that matter be posted after the vacation.
No, we also think so because now we have hardly 4, 5, 6 days, which will not. So can you ensure that they intimate him about the fixing? Yes. The writ petition.
Item number 21.
This is the matter where your lordship wanted to look into the act by virtue of which the reservation benefit is given for the candidates belonging to the exempted category.
Oh,
But I got the act.
horizontal. Horizontal reservation.
এটা কি রুলটা তো? And my lord, this is the rule which is framed under this act. My lord, kindly come to section 3.
Just give us 2 minutes. I just want to have a brief idea of what it is. In my parent state, we did not have any such provision. Just allow me 5 minutes. This is under section 3.
That is 3B.
Yes, reserve a percentage of vacancies.
Yes.
This is the only notification under 3B.
Yes. And here, my lord.
No, because it says from time to time. So this is the only, or there are others also?
My lord, this is the only which I found. There may be others, my lord. My lord, you will find notification number 302. It's in the second page bottom of 2002.
You are concerned with this?
Yes, my lord. And the last motion. From time to time, 30% shall be treated.
Where is 30%?
Well, the by promotion such and such. At the last paragraph, my lord, the Cooperative Service Commission or by promotion
No,
or by absorption.
sorry, we are not with you. You are referring to the second page of the notification.
Yes, ma'am.
Which notification? August 21, 2002.
21, 2002.
So second page 5 is election job workers enumerators.
Yes, ma'am. After that.
Yes, notification.
Notification. May I read one?
Yes.
Well, in exercise of the powers conferred by subsection B of section 3 of the West Bengal Regulation of Recruitment in the state government establishments and establishments of public undertakings, statutory bodies, government companies and local authorities act 1999, the governor is pleased to order that the total vacancies arising in a year under any appointing authority other than the vacancies which are required to be filled up either on the recommendation of A. Public Service Commission West Bengal, the West Bengal College Service Commission, the West Bengal School Service Commission, West Bengal Municipal Service Commission, the Cooperative Service Commission, or by promotion or by absorption of persons declared surplus by the state government or by absorption of such categories of casual workers and other workers as the state government may by notification specify from time to time, 30% shall be treated as reserved to be filled up by the persons falling within the exempted categories notified under subsection A of section 3 of the aforesaid act. Well, so the percentage of reservation for the exempted category is 30%.
30% in a very limited number of recruitment processes, not in all. Those conducted by PSC, College Service Commission, they are all exempted.
Well, kindly, Lordship, kindly see this. The in exercise of the power such and such recruitment of the state establishment and the establishment of the public undertakings.
Yes.
And recommendations of filled up is place order that
correct. But this will, other than this A, B, C, D, E. For filling up vacancies under A, B, C, D, E, this will not apply.
Please to, yes, my lord. May I read? Yes. There are the recruitment rules. So this is
so the exempted category will have no benefit in a recruitment being done by the Public Service Commission or the College Service Commission. Unless
their rules.
Unless a separate notification is issued for that purpose.
Because those are recruitment are done under those acts. Now that here in this case, if your lordship kindly see the notifications for the recruitment here. Page 46 is the notifications, employment notifications of this, my application for the appropriate order.
What is it? What happened?
Just what happened here, I fall under the exempted category.
That is not in dispute.
I am also the OBCA. Now, what has happened for the OBCA? There was no earmark post for the exempted category under that. There are only 3 posts of vacancies which were notified as the exempted category.
Oh, so they did the next point at which it fell did not coincide with an OBCA.
It should be adjusted. Now, I am the only exempted category candidate who participate in the entire selection process.
So 30% means every 30th vacancy is under the exempted category in the roster points.
Roster point is there, Lordship. The positions are earmarked. Then the person will, how it will go on. And the roster is also there.
There is UR.
Yes.
There is OBC.
Yes.
OBC A, OBC B,
ST, ST.
6 categories.
Then EWS is also
3 vacancies. There are only 3 vacancies.
Yes, my lord. Lordship, kindly come to page 48. Here, Lordship, the vacancies are UR4, UREC, you are exempted category. There are 2, SC2, SCEC1, ST1, OBCA1, OBCB2, and UR MSP1. My lord, I am only concerned with the UREC. There are 2, and there is 1 SCEC which was notified. But separately, OBCA EC was not notified.
It's not that is not notified.
It is there.
Will have to fall, that roster point will have to fall unless it coincides, because this is like an interlocking.
And then it has to be adjusted.
For example, reservations are interlocking. They must fall at that place where the place where it falls. Whatever vacancy is at that place, it will go to that class only. So this none of the vacancies under the exempted category fell at a point which was reserved for OBC A. That is the case.
That is the contention. My lord, in that case,
say whether I am an OBC A, if I have scored higher merit, why I can't be considered against UR?
Yes.
Yes, you are saying.
That is my case.
You can be. There is no difficulty.
There is no difficulty.
Then you will lose the exempted category tag.
If now that my case is that I should be adjusted against the exempted category.
How that can be done?
Because my lord, the
moment you say that I want to go in the merit sphere, then all tags have to be left behind.
But my lord, I may.
The reserved can cross over to the unreserved. That is settled. Unreserved cannot cross over to the reserved. Otherwise, it would amount to giving a reservation to the unreserved. This is the law. But you can migrate to an unreserved provided you go there on your own merit.
Now,
so which is the law? What is the cutoff mark for unreserved?
That has to be given. I asked for that cutoff marks, which was not
No,
given.
then how are you staking your claim? If you don't know, then
They have
how
not
you have
given.
made out a case?
They have not given. My lord, may I kindly.
Why they are required to give? When you have come to the court, you have to make out a case.
I made an application for that. They have not disclosed that. They have disclosed everything except the cutoff marks in answer.
You should have gone in appeal. Sir, under an RTI Act.
Now, my lord, may I place?
Why you are here?
May I place my case? Lord, you kindly come to the page number 63 once, my lord. Page 63.
Sir, unless you know the cutoff marks, there is no way you can claim a right.
No, now they have given. They.
So tell us what is the cutoff?
Kindly come
Under
to
the
this.
UR, what is the cutoff mark?
For unreserved, they have not given. For everything, they have given. Kindly come to page 63 once.
They have not given the unreserved cutoff mark.
Their lordship kindly take the trouble to
What is
consider
the unreserved cutoff mark? Just tell us.
the inter list has been annexed 137. Lordship kindly take the trouble. 137 is the list, and 138. Your lordship kindly take the trouble. UR 138, lordship.
Yes.
Serial number 22.
Yes.
Last UR was
48.6.
48.6.
What is your mark, sir?
Then his marks were the 43 serial number.
How you can process?
32.5.
How you can process? That serial number?
Well, this is not the cutoff. This is the weightage.
43. 43. Last. That page last.
Well, it's not cutoff.
He secured 32.5, and the other OBC A who has been given appointment 34, lordship, serial number 34. 42.7. Serial number 34.
But I humbly say it is not the cutoff, my lord. Kindly see.
42.7 has been given an appointment.
Yes, OBC A, to which my learned offense client belong.
He doesn't want any benefit under that category. What's the benefit that by performance he should be allowed to be considered as a UR category? It's not the cutoff mark. This is the result.
This is the result up to which the person has been taken. Then UR, my learned offense client wants to be considered to be UR. UR last we have taken 48.6. that is.
Anywhere you
Wait.
have said this, that the last person under the.
Yes, all.
Who has been appointed.
Yes.
Where just show from one place that you have stated this, that below 48.6, we have not taken any unreserved category.
Does you kindly take the trouble to consider page 10, sorry, page 90, which is my affidavit in opposition.
Nineteen.
90.
90.
90. I beg your lordship, pardon to trouble your lordship to come to 89. That continuity is there in 90. This chart, serial number 6, this was the point on which my learned friend's client has come before this honorable court.
So, anywhere you have said that nobody below 48.6 has been taken under the unreserved category. Because you are making a submission, we want to know the basis of such a submission. Where is this stated in any averment?
Yes.
Or anywhere you have said that this person at serial 22 was appointed.
Just in lordship. Just I'm just prior to that your quota has been fulfilled, lordship. I'm just finding it out.
Yes. 50% after one. One question. What will we see? The second question. This is only at the
Lordship, kindly consider. There were 4 your vacancies, out of which two have been filled up and two have been made backlog because nobody joined. That is the statement. If you lordship kindly take the trouble to consider page 93.
Page
93, lordship. 93. The paragraph starts with lordship so far as 93. So far as the employment notification number such and such is concerned, there are 4 number of vacancies, among which 2 numbers is for UR category 1 number each vacancies for SC, EC and OBC B respectively, which are still available. But since the recruitment is a time-bound process and the validity of the panel has expired, the respondent corporation had no other alternative but to close the aforesaid recruitment process and to treat all 4 aforementioned vacancies as backlog vacancies.
So no vacancy was filled up.
No, 4 was there. 2 have been filled up and 2 remained in the category of backlog because nobody joined within the time period.
We are not able to read any such thing in this paragraph. We don't know from where you are saying that.
Lordship, kindly consider page 90. Chart has been given.
92.
90, Lordship. 90. Tanmoy Chaudhary. In the chart, first serial number 1 is Tanmoy Chaudhary. You were joined. Roster point 25. Then 2, Ms. Doel Mondol. You were joined in the second list. 4 were the vacancies.
No, the second is not UR, it is under the EC category. Perhaps economic category. UR EC. Roster wise category is UR EC. We don't know what is. Oh, exempted category. Exempted.
UR EC. Then another serial number 5, Sujit Kumar Jos. You belong to UR.
Anyway, let him make out his case. Yes. How do you make out?
What should kindly come to the recruitment notification. But here I would be taking your lordship to 2 paragraphs. One is page 49. There is a note. Note says, in case of non-availability of the suitable exempted category candidate belonging to UR, SC, ST or OBC A, OBC B, for any such reserve points as mentioned above, the said vacancies shall be filled up by non-exempted category candidates belonging to UR, SC, ST, OBC A, OBC B, and case may be notification number such and such. My lord, here.
That is what we said also.
Yes. Now,
that is precisely what we said.
52, point number 10.
That does not help you.
And page 52, point number 10. Candidates whose names have been sponsored as exempted category candidates by the Directorate of the Employment Exchange against notification furnished by WB PDCL in this regard shall only be considered for exempted category reservation. Candidature of the candidate applying under exempted category shall, upon verification of credential, if found not to have been sponsored as exempted category by the Directorate of Employment Exchange, shall be summarily rejected. Candidates are therefore advised to confirm with the Employment Exchange about the sponsorship of the exempted category. Then I was sponsored.
So how are these relevant,
My
sir?
lord, now
There is
what-
no dispute that
what-
you are claiming under exempted category.
now what my
There
lord
is no
saying-
dispute
saying-
that you have a particular. What is your marks obtained by you?
My lord, kindly come to the list.
How these facts are relevant unnecessarily?
32.5.
32.5. How you can be considered as you are?
Now you are EC. There are the earmark post reservation for UR for exempted category.
Yes.
That is lordship given under the
Must be. You need not stress upon that. There must be UREC.
UREC. But UREC, in my humble submissions, and it is relevant from the records that UREC there is no appointment.
Maybe you
There is-
cannot get that. You can get UR. You cannot get UREC.
No, that has to be because the recruitment notification clearly reserves the post for the UREC category.
Correct. So therefore, a UREC can get it.
Qualified there.
Then you can't go there. You can go to UR. You cannot go to UREC.
So
That means what you are trying to say is accepted. Then if an ST has marks, he can go against UREC.
For horizontal, no. For for vertical reservation, no.
Yes.
For horizontal reservation, my lord, the answer would be possible lordship. My subject to correction, my lord.
Perhaps it is the inverse. For vertical, yes. In case of vertical reservation, he will migrate to the UR category. But for horizontal, how he can migrate?
Here also, he has to migrate from OBC A to UREC. So vertical to horizontal.
Cannot be.
Because lordship, kindly come to page number 2031.
What is the cutoff in UREC?
UREC cutoff is not given.
So how are you making out a case? We don't know.
I did not give because nobody under the EC category has been appointed. UREC category.
That does not mean that you know the cutoff.
They did not. They deliberately has.
Sir, if they did not, you ask them under RTI.
Yes.
They did not. Did you go in appeal?
I challenge it, my lord.
How can you? That is what we are asking you. There is an appeal provided
The
under
rest
RTI.
of the numbers were furnished, except
So therefore, that it becomes saleable in a writ jurisdiction.
well, my right accrued on the basis of my claim that I belong to that UREC reserved category.
You never belong to UREC.
I applied.
You belong to OBC AEC category. You do not belong to UREC.
My
category.
candidature was sponsored by the Employment Exchange.
Yes.
By virtue of this act, as
Yeah.
well as by the notification, my lord, if the candidature is.
You said you are a candidate under OBC A.
I am an OBCA.
Then
I am
how you are
also
saying you are?
both.
Yes.
I am OBCA as well as I am also falling under exempted category.
Correct. That
The OBCA may be a land user.
OBC A EC category, you are falling in OBC EC category. OBC A EC category.
You are EC category. My lord, my question is that OBC.
You are not under UREC category.
Well, unreserved EC category, but OBCA EC category, where is that? They have not notified that.
That is your case, that you are under OBC A EC
They have
category.
not notified that. For OBCA EC,
They
they
are
have
not
notified.
required to, unless that falls at the.
That is a clear violation of that act, my lord, because 30%.
What is your relief in the writ petition? Read your prayer.
Yes, my lord, kindly come
Yes,
to my
read your prayer.
My lord, my prayers are in page number 35. Read in the nature of mandamus directing respondents, the men in service immediately fill up the post as per the notified vacancy for unreserved exempted category. Candidates by giving preference to your petitioner. Read in the nature of mandamus directing respondent, main agents and subordinates to consider the representation, that is P8. Read in the nature of certiorari, interim direction. These are the prayers, my lord.
So how can you have prayer A? Tell us.
Prayer
What is your right to this prayer A?
Yes, my lord. Kindly come to my application. Lord, kindly come to page 119. This is the admit card. My lord, kindly come Are you WBPDCL departmental candidate? No. Are you eligible? WBPDCL contract? No. You are exempted category. Answer is yes.
Who is saying you are not? Why are you laboring on this? The point is how you can get prayer A, how you can be adjusted against a unreserved category. That's the only thing.
Yes,
There is no dispute that you are OBC A, EC category.
I am EC category, my lord. I applied as EC candidate. I never wanted though I am an OBCA, but at the same time I am also an EC category candidate, my lord.
How many times you will say that?
So kindly see this
OBC, EC, that is the admitted position
now
from both sides.
Now,
There
Lord, you
is no
kindly-
dispute. You need not labor on this fact.
Now, Lord, you kindly come.
How you can cross over to the UR, that is the only thing.
Yes. Now, Lordship, next thing, my lord. 170. 117. 117.
Just now you have read which page?
Sponsoring
119.
119. This is 117. Document dated 22nd November 2018. Sponsoring of the candidates for supervisor mechanical. The receipt of your memo referred above notifying the vacancies for the post mentioned. The subject exempted category is acknowledged and thanks.
You are at serial 11. Yes, you are at serial 11.
Well,
you are at serial 11.
Yes, yes.
Yes, OBCA. So OBCA, you have been recommended as OBCA, but you fall in exempted category.
Exempted category.
So OBCA exempted. Why are you laboring on this? We don't know. This is not an issue in dispute.
So
Why
now
you are
whether I
arguing
should
this?
be considered as an exempted category or not?
No, whether you can be considered as against UR. That is your claim against the UR vacancy.
You are
No, sir.
You are
Come again to your prayer. Read your prayer.
Unreserved
Exempted. All right. How you can cross over to under which provision? Where is the provision enabling you to cross over to UREC? Show us.
So, my lord, the question is,
that's the only issue. There is nothing else. You need not show anything else. This is your assertion, and this right has to be established with reference to which provision?
My lord, there is a judgment of the Supreme Court which I have.
Show us. Don't show us that general judgment that reserved can cross over to unreserved. The point is whether one reserved can cross over to another reserved. UREC is not unreserved. UREC is reserved. It is reserved for those in the exempted category. So whether it is like saying whether an ST can be considered against SC.
May only say, let you kindly come to page number 2031.
Yes.
This is the action taken by them. This WBCTL has done.
Huh?
Due to non-availability of the required numbers of the candidates.
Sir, how you can go to UREC? Tell us, show us any judgment that one reserve person can cross over to another reserve category. Another reserve category. Don't show us the law that you can go to an unreserved category. That's not the case. You want to migrate from one reserve category to another reserve category. Is it permissible? Though you belong to a reserve category A, you want to be considered against a reserve category B. Is it permissible? That's exactly your case. That's your prayer.
May place it in a different way.
You may not. That is your prayer. You may not place it in a different way.
Be treated. My candidature has to be treated under unreserved exempted category.
Which is a reserved category.
Unreserved
exempted is a reserved category. So whether one reserve person can have a claim to migrate to another reserve category. Any judgment you
Well, it depends on lordship. One reservation is the horizontal reservation.
Forget horizontal, vertical. The moot question is a person in reserve category A, whether he can cross over to a reserve category B.
If a person can migrate from the vertical reservation to the horizontal reservation.
We are not on that. That is not the issue here. Your prayer is that I am a reserve category OBCA. Consider me against another reserve category, unreserved is. So tell us.
Well, when I have been sponsored by the employment exchange.
Forget about sponsor. These are not issues. These are not issues. The sole issue is one reserve category candidate wants to go to another reserve category. Can he do so? Tell us.
In my humble submission, I can. Lordship, if your Lordship wants, I will find out a judgment.
No, so that is the only issue, sir.
Judgment, Lordship, but
Only issue arising for consideration after.
Item number 22.
Lordship, I am for the appellant led by Mr. Shamimul Bari. Lordship, there is a difficulty. We have received the documents of deposition and other important documents today from the client, Lordship. Kindly grant us the leave to file a supplementary affidavit and come back. The record of evidence we have just received today, Lordship.
No supplementary. You have got your brief.
Lordship, Mr. Bari is leading me. Mr. Bari will do the matter.
Let him be here. As per list after one.
The only thing, Matt, this is probably a third time adjournment is being.
We are not going to grant any leave for filing a supplementary. Just simple adjournment after the vacation. Okay.
Three 23 Mala. And for the writ petitioner respondent. Last day, my lord asking for one day one particular. So my lord asking for the translator.
What is the issue? What is it?
Hello, we are challenging that there is a disciplinary proceeding against the petitioner, and there is an appellate order authority affirm the same. That was set aside by the single bench, and before that, we are challenging the same, coming for a lordship. Page 125 of the stay application.
And age, my lord, 262. 262, my lord. 231 only. Who is the earlier, Miller? The new is
230.
231. No.
No, sir, this is the
This is the summary of
presenting officer's submission.
page 101 of your lordship's brief. This was the it starts from page 101, concluded at 106. And where is the translated copy you have?
मतलब legible Bengali copy thereafter मैं translate
Is the order passed in the earlier read proceeding? The court's order in the earlier read proceeding.
Case, my lord, 67. There.
Where is the single judge order?
Page 1.
Let us.
Which is the honorable single judge of the earlier writ petition.
No, after this.
125.
Why he has interfered?
So may I just indicate one thing, my lord?
You just. The direction of the learned single judge. %50 back wages of.
No, see, this reply which my learned friend has showed, this is the reply of the earlier charge initially which I submitted, and the honorable division bench has set aside this reply.
No.
Yes.
This reply has not been set aside.
No, Lordship, kindly see the order
Don't
of
say the reply was set aside.
the honorable division bench says that the proceeding will commence from the stage of charge sheet.
Correct. So don't say reply was set aside.
So the charge sheet was issued. I submitted a reply pursuant to the order passed by the division bench. That reply was not considered, but the inquiry officer considered this reply and found me guilt. If your lordship kindly appreciate the penultimate portion of the order passed by the division bench.
So therefore, according to you, the inquiry will proceed according to the charge memo, but documents will not be looked into.
Document will be looked into after submission of my reply, because the earlier proceeding has been set aside. Now I put this question to myself.
Did the court in the earlier occasion set aside the charge memo?
No, charge memo was there.
Then,
so
what is a charge memo, sir? Tell us first.
The charge sheet was against me that I have defalcated 2 lakhs and 5,000.
No, what is a charge memo? A charge memo must be defined under your conduct rules.
Yes.
It is a communication by which the articles of charge, the statement of imputations of misconduct, the list of documentary evidences, the list of witnesses, all this together is the charge memo. So therefore, what is precluded? If the charge memo is there, then all documents in the charge memo can be considered. Why not? What
Inquiry
are you
officer
saying that everything goes? Then what
inquiry
remains?
officer relied upon the earlier submission, the departmental proceedings.
He will rely on that.
That has been set aside.
You may say so. We
Lordship,
don't find
kindly-
it. We don't
Lordship,
find it
for
from
my
the.
satisfaction, Lordship, kindly
You keep
once
saying that that earlier reply has been set aside. We don't find any such observation in the judgment. That reply is set aside. We have never heard of such a finding. That petitioner's reply is set aside.
Lordship, kindly come to page 71.
Please read where it says the reply is set
We
aside.
set aside impugn order as well as
Correct.
the inquiry report.
Correct. That's right.
And all orders passed pursuant
Correct.
thereto in the disciplinary
Correct.
proceeding.
Correct. So reply cannot be set aside. That is what we are saying. That is a misconception in your mind.
Lordship,
That
kindly
reply
say the
is set
bank will cause immediate fresh inquiry in the matter on disciplinary proceeding from the stage of charge sheet.
charge memo. So charge memo is intact.
Charge memo?
Is intact.
Yes, it was
Charge
there.
memo is intact means all documents are intact with the charge memo. They cannot be looked. They have to be looked into.
But the inquiry officer, Lordship, relied upon the proceeding of the earlier disciplinary proceedings, which has been set aside.
We have gone through the inquiry report, sir. We have read the inquiry report. We have gone through the entire inquiry report.
Lordship has gone through. It has
Yes.
specifically stated
See, now
that
we are
in the
telling
earlier proceeding.
now
that
we are
was the
telling you what you have done. When charge memo was issued, you said that I withdrew this money from the safe because I was in financial distress.
Because my subsequent reply that
Then-
was not considered.
Then I have given it back. Then during the proceeding, you say that no, it was taken by because the branch manager told me to take it out and give it to some Mr. Chakravarti. He was in distress. Now you change your entire version. I have given it to him. Thereafter, 3 persons have deposited it on his behalf. So why the inquiry officer will not look into both? Why he will look into only one?
Because of the earlier proceeding was set aside.
So therefore, if that is only your submission, then we can consider it right now.
Because Lordship,
If the proceeding is set aside, then all the documents now cannot be looked into.
the document relied upon, see, if the inquiry proceeding is set aside, earlier inquiry proceedings, I put this question to myself, whether the inquiry officer subsequently can rely upon.
Sure he can. Sure
Once
he
it
can.
has been set aside.
Sure he can. 100%. Nothing comes in the way of consideration. Proper consideration is a different thing. In accordance with law is a
In
different
fact, the
thing.
subsequent
That will
reply,
not
that
be
was not at all
obliterated from the
considered.
record. All the documents which were before him in the earlier inquiry, they will be obliterated from the records because the inquiry was set aside.
That
Wonderful submission.
They accepted the order passed by the division bench. That was not challenged.
Who accepted this order?
Yes,
You
the
should
bank
have
also-
challenged it.
The bank also has accepted it and they proceeded
Anyway,
further.
if that is your
Now,
only
Lordship,
submission, then
kindly
nothing.
the subsequent reply after.
So your submission is that reply now cannot be considered.
See, that is my understanding in terms of the order
Well,
passed by the
we
division
don't,
bench.
we are being very clear that we find it very difficult to accept such submission on going through the earlier order. The proceeding is set aside. It is remanded to be conducted from the stage of charge memo. That does not mean all the documents are gone. Preposterous. Cannot mean. They have to be
So
considered.
my subsequent
Maybe the
reply was
subsequent-
not considered.
The subsequent one also has to be considered.
That was not considered.
That has been considered. They have said that you have changed your version. That they have considered it. They have said that both now you have given 2 versions.
So that was recorded in the.
You
because
don't, you
out
don't,
of-
you
out
have
of
never
compulsion-
denied, you have never denied that you gave this.
Yes, it was given.
Yes.
Compulsion that was recorded in the
It is an
order of
admitted
the
position.
division bench. It was
Now
recorded.
you may say the second one is also under a misconception. You keep saying that.
See, my statement that was corroborated from the bank's document because in the earlier proceeding, the inquiry officer came to the conclusion that I deposited the money. But from the record, it appears that was deposited by some 3 other persons.
Show us any judgment that if an inquiry is set aside, all the documents which were considered now cannot be considered. Any judgment. One single judgment. It cannot be, sir. That's not the legal position. You very well understand what the law is. A proceeding is set aside only on the grounds of perversity, incompetent authority passing the order. If it is founded on no evidence, if it is founded on evidence which is extraneous to the consideration, or if the findings are perverse. On these grounds, an inquiry can be set aside. It cannot be that now these documents will not be looked into.
Lordship, the ground for set
There
aside.
cannot be a presumption to that effect based on a reading or an inference based on the setting aside of the inquiry. How it can be?
Lordship, the ground of setting
Then
aside.
it cannot. Then it should not have been
was
set aside.
That the disciplinary proceeding as well as the inquiry officer proceeded on a long premise that I have deposited the money. When the actual fact was brought to the knowledge of the court, it was remanded.
See,
that
the order is
all other
clear.
previous
Order is clear in what it says. It says that how can you proceed with this finding that he has redeposited it when three other persons have come forward to say that they have deposited it. So they have to consider which they will accept. They have to consider. That does not mean they will not consider
the other ground. The disciplinary proceeding who passed the order, he acted as the appellate authority and affirmed his own order.
So, all right.
That was another ground for challenging the writ
That
petition.
will not invalidate the disciplinary authority's order. That may invalidate the appellate authority's order. You may be requiring a fresh consideration of the appeal. That will not invalidate the disciplinary authority's order. That will not. The same person became the appellate authority.
Yes. Maybe the person is different, but the designation, hierarchy. The assistant general manager of the sponsor bank, he was deputed as the general manager. He acted as my disciplinary authority.
Under the rule, who is the competent person?
The disciplinary authority is the general manager and the appellate authority is the chairman of the board of directors.
So
but
you
in my
preferred your
case,
appeal before the chairman.
the general manager who acted as my disciplinary authority, he acted as the appellate authority and I confirmed the order.
Instead of chairman, the deputy general manager or general manager has done.
The general manager who was the disciplinary authority, he acted as the appellate authority.
Yes, on this, what you have to say?
This is document. It is that.
Huh?
There is a COVID situation, my lord. The acting, this is the sponsor bank provided one officer for the that time for disciplinary proceeding, and thereafter, my lord, it should be considered by the chief.
Now, therefore, in these admitted facts, you want reconsideration of appeal or you want consideration of the merit? First decide. If you want reconsideration of the appeal, since it is admitted, we can remand it to the appellate. If you want to contest, we are hearing you. What the judgments you want to rely upon? Let us proceed.
Mr. Kindly grant me some time if we can find any judgment that remanding or upon setting aside, if that cannot be relied upon.
The learned advocate, we have You also come with judgments.
Twenty-four, my lord. I am for the respondent, madam.
What happened, madam? Yesterday also it was added.
I have not received also. They have not provided also complete copy also.
What they have not provided?
Complete copy, my lord.
Why give him a copy? MS so and so.
Thirty-five.
Item 25, my lord, I'm praying for not. I'm praying for not. I don't see advocate on the call, my lord.
As spread list after the summer.
Six.
My lord, I am for the appellant petitioner, my lord, coming up against an impugned order of 16 May 2026,
My lord,
whereby the entire gratuity amount was directed to be paid by us.
my lord,
The
before my
affidavit of
learned senior proceeds, my lord, in this matter, Mr. Moina Ganguly, led by Mr. Shomo Mojumdar, is appearing for the respondent. My lord, due to some personal difficulty, my lord, Mr. Moina Ganguly had to leave court
I
and
am only praying that the delay be condoned. There is a short
takes
delay.
accommodation. Let it be tomorrow.
My lord, then it will be kindly make it not this week.
As spread
Tomorrow I have some difficulty.
list.
Great.
27.
Lordship, item number 27, Mr. Ombodesh Ray is appearing on behalf of respondent, Lordship, but he is not come to the court due to some medical emergency, Your Lordship. Kindly make it not today.
None appears for the
I am appearing for the petitioner, my lord. It is that matter, Mr. Amol Sen, learned AG, Tijan AG was appearing, my lord, and sought time to produce records. Now, under the changed circumstances, your lordship kindly grant.
the state respondent is un. 28.
28, no, 20, no, 20, 29.
What happened?
So wait,
What happened? What happened?
None appears for either parties.
my lord, I am appearing on behalf of the petitioner, my lord. In this matter, what happened, my lord, it is the petitioner is paid for compassionate appointment. My lord, Siemens committee has recommended his name. My lord, I am reliant upon Mrinal Kanti Das judgment. Your lordship on the last occasion asked the state authority to file affidavit in opposition. No opposition is forthcoming, my lord.
What can be done in this circumstance?
Yes.
The state is second week after your second week after second week after the opening. Any date. Give him that.
22nd. Good.
If I am for petitioner, have some, my senior, Mr. Onindo Bose, have some personal difficulties. Have some personal difficulties, that's why I am.
Not today.
My lord, I am for the appellant. My respondent is Mr. Tapan Mukherjee, senior advocate, appearing in the, he is no longer, my lord. So after vacation.
State respondent.
Yes, my lord, state respondent. After vacation, my lord.
But then I'll the state not today.
Thirty-four and 35, my lord, I will take for the petitioner. Now, my lord, they have filed one supplementary affidavit. My lord, we have to file a supplementary opposition to that affidavit.
And they have filed a supplementary.
Yes, my lord, they have initially filed an opposition, my lord. Thereafter, they have filed another supplementary opposition. My lord, your lordship granted us leave to file a supplementary reply, my lord.
Could not be filed yet.
Whom to serve? The problem is this, my lord. Even if Mr. Joyanto Samanto is appearing in the one matter and Mr. Shishanno Bandyopadhyay in the other matter, item 35, both are tagged. And my lord, both of them are not there, my lord. My lord, let me after vacation, my lord, let us know who is appearing, my lord. I have to serve the entire copies.
For ensuring compliance with the court's law.
হ্যাঁ আমি তো বুঝতে পারি না ধরো state is there state আছে
How much time they will take for constituting the panel?
probably not this side of this vacation there is no chance
This way we are saying, how much time does we have to be decided our panel? That side is always more informed than us. Yeah?
No, some will know more than the others.
Some will be having a very fair idea of what
Lord, that matter where your lordship directed mediation has failed.
this also state has to.
state is there
Lordship will
2 weeks after vacation এটা 2 weeks করে দাও
The state, none of
everything. Lord, the report must be with your lordship, the file.
we'll see.
It will be a short report.
It's an only mediation failed,
3
that's
days
all.
we had tried. 3 days.
If it's a long report, then that will cast a.
No, I don't think it's a long report because he said we have given our best efforts.
Mediation failed. So that distribution of the.
no compassionate appointment
Compassionate appointment, whether the signature of the sister.
Therefore, we were wondering whether she would be willing to distribute the benefits of the compassion.
We had given that option. We've given everything.
Because
mother is not willing to give NOC to
lack of trust.
yes
Lack of
NOC marriage
We'll see.
23rd হলো
For the petitioner, your lordship, led by Mr. Sudipto Dasgupta, kindly make it not today.
What do you want?
And for the petitioner, your lordship, led by Mr. Sudipto Dasgupta, kindly make it not today.
Not today, yes.
38, my lord, I appear for the petitioner. Mr. Amol Sen is supposed to appear and file an affidavit, my lord. Only thing, my lord, there is an interim order, my lord, which is, my lord, existing till 22nd of May.
There is none to represent the state.
Lordship, I am for the petitioner also in item
Not
number
today.
39.
One, two, 43, 44, 45, 46. I am paying for not today, my lord. I am paying for not today, my lord. Mr. Sanjay. That's true. 7, 48, 49.
Your Lordship, kindly fix this matter after vacation. The advocate on record has gone and undergone surgery, my lord. 49.
For the respondent. He is the advocate on record or arguing counsel?
Advocate on record.
What is his name, madam?
Shayan Dotto.
We are informed by MS so and so.
One.
My lord, Mr. Tapan Mukherjee is appearing, he is to file an affidavit. But let that be after vacation, my lord. After holiday. After holiday.
54, 555, my lord, last occasion, your lordship granted leave, my lord, to file a supplementary affidavit annexing, my lord, the OA, original OA application, my lord. The state is also present, my lord. Today, my lord, they are not present. My lord, allow me, my lord, file a supplementary
Who
affidavit.
you will serve it on?
I do not.
So don't give it right now. Serve it, then you give it. Mr. So and so.
Deep, deep level, deep level. 56.
Well, 56 and 66 both relate to resignation. Well, they are supposed to come back with the instruction, my lord. Other similar matters have been fixed on 9th. Can these two be on 9th?
9th of June.
June, my lord. Other matters, my lord, 56 and 66.
Mr. Royal and advocate sub.
But I prefer not today, my lord.
Yes.
For the Public Service Commission. I am for the Public Service Commission.
Not today.
My lord, tomorrow I have certain difficulty. My lord, can this be on the next day?
All right, tomorrow we'll see.
See, I prefer not today, my
Lord,
lord.
I am for the Public Service Commission.
Yes.
67 or 67, my lord, I am paying 10 days time because, my lord, a double bereavement has been occurred in the family of the advocate on record. First, son died, thereafter father died. After 3-4 days. 10 days time.
Mr.
Yes, sir. Yes, sir. I'm grateful.
68, 69, 70, 71, 72.
Before your